appeal in the matter of LM, Albania, and the Secretary of State for the Home Department.
Yes, Ms. Briganza.
Good morning, my lords. I appear on behalf of the appellant in this matter together with Miss Butler, and Mr. Heath appears for the respondent.
Yes, I can tell you that we have read the skeleton arguments, the judge's judgment, and the decision letter.
Thank you. That's very helpful, my lord, to know. May I, before I turn to my submissions, just by way of housekeeping, raise one matter on the skeleton argument?
Yes.
Miss Butler's handed in, my junior's handed in this morning, a very, very minimally revised skeleton argument, just in terms of, so that your lordships have that. There is a date change at paragraph 2, and then there is at paragraph 9. Does your lordship have the version handed in?
9, yes.
The final line, the words "a car driven" are crossed out, and the revised version simply says "with her sister's boyfriend." The paragraph 17 has struck out after the date, having obtained legal advice. And finally...
which line was that?
Which date?
That's,
2 dates and 17.
17, my lord.
The date in the first line, date in the last
On
line.
the 3rd of May 2018. Paragraph 17 reads the date, and then it says having obtained legal advice, and that comes out.
Right.
And then finally, the revised version should have at paragraph 34 the 3 insets.
Yeah. 3 what?
Insets, it should only be 2. The judge's approach to the expert evidence and the judge's very brief reasoning.
Yes.
And then the 3rd part comes out.
Right. Yes.
So, so that is the that's how the corrected skeleton is different from the previous version. And if it assists, we can email the very final version. My lord, this is an appeal from the judgment of Mrs. Justice Whipple, as she then was, of the 15th of November 21. And in her judgment, she dismissed the appellant's application for judicial review of the conclusive grounds decision, which is dated 11th of November 2020. And that decision was a negative conclusive grounds decision, finding that the appellant was not a victim of trafficking, essentially on the basis of her admitted dishonesty. By order of the 15th, the claim was dismissed and permission to appeal was refused. The appellant appealed relying on 3 grounds, and those 3 grounds are now subsumed into the 2 grounds before your lordship. The 3 grounds concerned the judge's approach to credibility, in that the court below had erred in accepting the appellant's account could be rejected because of her dishonesty without considering the context and the reasons for that dishonesty. The second ground concerned the judge's approach to the expert evidence. Essentially, the court found that it was open to the Secretary of State to reject the expert evidence, notwithstanding there was no expert evidence countering it, and that the reasons relied on in rejecting it were in fact unsustainable. I'll come to the detail of those. And the final ground, which has now become our first part, is that, and this was the overarching complaint, was that in the same way that the conclusive grounds decision failed to apply anxious scrutiny and an intensity of review of the extensive documentation in its varying forms and types, equally the judge erred in her approach to reviewing that decision, which, by reason of the nature of that decision, required an intensity of review and particular care to be taken. And the very short reasoning at the end of the judgment fails to demonstrate an application of anxious scrutiny to the...
Could you explain what anxious scrutiny means in practical terms?
In practical terms, it requires that against the background of the nature of the decision, the impact that decision has on the individual as to whether or not she's a victim of trafficking. It requires particular care. It requires that all of the factors and those supporting the appellant's account are given due consideration. It requires that the evidence is considered in its totality. And it requires, in this instance, and which is a second part that I will come to, a direction, understanding and application of what is described in TVN, the essential standard of fairness, that whilst an individual, in this case the appellant, may, in parts of her account, provide parts that are false, that she admits to being false, that does not mean that the decision maker can then jump to the conclusion that the account is to be rejected in its entirety, which is what happened in this case.
How does that approach differ from the approach of any other judge dealing with any other issue?
It requires a particular intensity of review, and I'll take your lordships to TVN and MN. You'll appreciate.
I come from a different background. I come from a family background, and the approach to, for example, cases of child abuse or domestic abuse, would suggest would require all of those criteria. That's a strikingly similar approach.
And as may be the case, but I'm in terms of, in this case, assessing whether the individual is a victim of trafficking because of that context. There is a particular requirement, a higher threshold, if you like, in weighing up what the evidence is, in analysing that evidence, and then in providing the reasoning for accepting or rejecting that evidence.
At what level is this anxious scrutiny test to be applied? Is it a test which the decision maker must apply, or is it a test which the reviewing court or tribunal must apply?
Both, my lord.
Both.
And that's set out in MN and also in TVN. If I may go on to address you on the way that we frame our argument, and then take you to specifically MN and TVN. The essence of the appellant's case is that, considering what is set out in terms of the principles set out in MN, considering what is set out in TVN, and applying that to the way the conclusive grounds decision was structured and reasoned in this case, and applying it also to the court below's review, that there are very clear errors of law and clear misapplications of what MN and TVN tell us.
Yes.
So that then takes me to the two issues before you. The first as to anxious scrutiny, and the second the Lucas direction. And of course, to some extent, there is an overlap on both, but we have separated it in those two ways. On the anxious scrutiny, it's the appellant's case that essentially the way in which it can be demonstrated that the court below has failed to apply anxious scrutiny are four essential elements to that. The first is the failure to consider the context and reasons for the dishonesty that is so very heavily relied on. When I take your lordships to the judgment, I will rely on the repeated references to dishonesty and lies and patchwork of lies.
Are you going to give us the four? You said there were four.
Yes. The second is the rejection of Dr. Wootton's report, and that was on the basis that the appellant's mental health was attributable to other causes. And in fact, Dr. Wootton made quite clear in her report that certain of the experiences that the appellant had complained of predisposed her to the diagnosis that she then made of complex PTSD, moderate severe depressive disorder, and severe anxiety.
Was Dr. Wootton saying that saying that this was diagnostic of trafficking or consistent with trafficking?
She said it was consistent with the account, and what she said was she set out the number of experiences that the appellant had presented to her. She applied to her examination of the appellant, her analysis of the medical records, her assessment speaking to the appellant's sister, her own expertise, and made this diagnosis, and then found that particular experiences predisposed the appellant to her diagnosis. The actual trafficking on which she'd given a consistent account repeatedly and varying as to what happened to her prior to her arrival, that in fact had been, those experiences had precipitated the PTSD. And then she found that what the appellant then experienced after her arrival in the UK perpetuated the symptoms. So she did more, if you like, than saying it was consistent. She drilled down into saying why she found it was consistent. And that evidence is essentially, it is rejected within the refusal letter for a number of reasons, varying in the sense that they make, from attributing the appellant's diagnosis to other causes to then referring to the Home Office having vast array of information before it, not before professionals. And on that basis, what we say, the second part on anxious scrutiny, is that the court below erred in how it dealt with Dr. Wootton's report. The third point is the Mabanga error.
Third point is?
The Mabanga error, my lord. The Mabanga error is in terms of the assessment of credibility, that the decision maker errs in a step-by-step process where first the inconsistencies are considered and found to damage credibility, and then the decision maker moves on to consider whether, in the decision maker's own words here, whether the expert evidence mitigates against it, rather than considering the evidence in its totality. And
so your point is the decision maker was wrong to consider credibility sequentially rather than in the round.
Absolutely.
Yeah.
And then the fourth point, going to this failure, demonstrating a failure to apply anxious scrutiny, is made up in this way. The court below's very brief reasoning, demonstrating it appears a reluctance to apply anxious scrutiny by making this reference to it not being for the court to look for infelicities within the decision. Again, there is an overlap here in not having dealt with the Mabanga error and not having dealt with two additional parts on which extensive submissions were made. That's the telecommunication evidence and what is described as further lies to the probation officer. And then finally on that, my lords will have seen within the conclusive grounds decision that essentially they're repeated boilerplate. They're described in TVN as boilerplate sections or cut and paste.
Well, the same wording appears at several points, and you say these are words commonly found in decisions of this sort.
Yes, from the outset, and again, you'll see the same exact same wording is used in the decision in TVN. So from the outset, where we say actually the wrong question is addressed, which is the wrong question that's addressed is she telling the truth? The right question is she a victim of trafficking? And from the outset, it's framed in that way. The same copy and paste paragraph there. Then when it said this damages your credibility, and so we look to see if there's mitigating circumstances, and then where the writer says, these professionals do not have access to vast arrays of information. So throughout the letter, it is littered with these examples of boilerplate reasoning that should have immediately alerted the court below, and the court doesn't address this, to, again, the failure to apply anxious scrutiny and intensity of review to what was before the single competent authority. And then on the Lucas direction, the point there essentially is that when there is no such direction in the decision letter, there is no direction saying, whilst part of your account is admitted to be false, that doesn't mean to say that the other parts are not true. And equally, within the court below's reasoning, it is not applied within the some 8 or 9 paragraphs explaining the judge's conclusions.
The way that this point seemed to me to be argued, at any rate in your skeleton argument, was that the error was that the judge did not give herself a Lucas direction, which I'm bound to say I didn't understand, because the judge is not a fact finder, the judge is conducting an exercise in judicial review. The way you've just put it is that the fact finder should have given themselves a Lucas direction. Are you advancing both limbs? Because the first of those limbs didn't fly off the page.
Well, I rely on the fact that the fact finder did not make any type of Lucas direction. Yes, I do rely on that. My Lord, I accept what you say in terms of your analogy about it flying off the page, but I say in turn, the Lucas direction again, and I will take you to the relevant parts in TVN setting this out.
TVN was talking about the decision maker.
Yes.
Having a Lucas direction,
Yes.
as indeed was NN.
Yes.
But do you persist in the submission that the judge conducting an exercise in judicial review should have given herself a Lucas direction?
The way that we put it is that the judge in her review should have been aware that the decision maker is required to have regard to it.
Right. So,
and that is a failing on the judge's part.
right. So you're not saying the judge should have given herself a Lucas direction. Is that right?
No, because the judge against this higher threshold of carrying out an intense review of the decision maker below was required to have that in mind, but not give herself, because she's not assessing the facts herself.
So the complaint is that the judge failed to attribute sufficient weight to the fact that the decision maker did not give themselves a Lucas direction.
Yes.
Is that how you put it?
Yes.
Sorry to chase this down, but obviously, no doubt you will, when you look at our judgments, rightly see whether we have applied anxious scrutiny. But that isn't how you put it at paragraph 3 of your skeleton. Your little 2, you put your 3 grounds of appeal into 2. Did the judge err in failing to give or apply a Lucas direction? That is not, did the judge err in failing to identify that the decision maker had not given a Lucas direction? Are you changing that ground?
No, what we're saying, my lord, is that did the judge err in failing to apply a Lucas direction in assessing what the decision maker and how the decision maker...
Well, you said in failing to give or apply. Sorry to be picky, but if you are asking us to apply anxious scrutiny, we're looking at words.
Yes. Well, I rely on, the way that we've put it, in failing to both give and apply the Lucas direction.
Well, how can you sustain that so far as the judge giving a direction in the light of the way paragraph 33 of the judgment is phrased?
My lord, the way that I...
What she says in 33, it doesn't set out Lucas in full, but she says the fact that a person has lied with authorities is not determinative of whether they are a victim of trafficking. CMA Somalia. My only quarrel with the judge is that I think she's got the wrong paragraph number there. I think she's referring to paragraphs 32 onwards of the decision in MA, where the whole Lucas, well, not the whole Lucas, but the Lucas principle is set out in greater detail. Now, why isn't that sufficient? Why isn't that the judge giving us herself a sufficient direction?
My lord, what we say is the difficulty with that is that the Lucas direction is not simply in terms of the significance to give to lies, but also to recognise that that does not mean that the entirety of the account is unreliable. So it goes a bit further than simply saying about the significance. It goes to saying that actually that jump cannot be made.
So which particular part of the Lucas direction, or the principle in Lucas, are you saying is not taken into account in the way the judge has characterised it?
That that equally those parts of the appellant's account that are consistent, that they in turn can mean that in that regard, that the appellant is telling the truth, that it's not simply what the appellant says. It sets out here that the lies will vary from case to case, may conclude as a matter of great significance. It doesn't go on to say, and also that does not necessarily follow that the entire account is to be rejected.
But that's in the first sentence of that paragraph, isn't it? That's exactly the point she's making in the first sentence.
Well, she says
the fact that the person's lied is not determinative of whether they're a victim in trafficking. So she's saying you can't make that jump.
What we say is, in fact, she doesn't go far enough there, and that's then borne out in the reasoning, because the reasoning repeatedly focuses on the dishonesty of the appellant without recognising or in any way considering the extent to which the appellant was consistent in what she said. So that's how we put it.
Well, that submission goes beyond Lucas, doesn't it? That's about credibility generally.
I think, my lord, if I can, if I may take you to the Lucas direction, what's said at it's tab 10 of the authorities.
This is Mr. Locke.
Yes. Tab 10, page 260. 260, my lord. Paragraph 29, and specifically that where it sets out the claimant in this case makes the complaint that the SCA jumped from rejecting the claimant's factual account on limited and specific details to reaching the conclusion the claimant's evidence about all aspects of his case history should be disbelieved. It is also a common rule of decision making. A decision maker needs to take special care to make the jump from concluding that an individual is lying on one issue to the conclusion that other parts about what happened to him should be rejected as lies. And then at 30, three lines down.
He quotes from Udin.
Yes.
This isn't Mr. Locke giving himself a Lucas direction. This is Mr. Locke looking at the decision maker.
Yes, my lord. And then setting out, which again ties into the anxious scrutiny point at paragraph 31, the guidance provides extended and clear advice to SEA to caution them that victims of trafficking can lie for a number of complex reasons. And then jumping to the line beneath that, Lord Justice Ryder classified a Lucas direction as being of general application. He was right to do so. It's an essential standard of fairness to be observed by anyone who's having to make a judicial, quasi-judicial, or even administrative decision. So what we say on that is that whilst I accept at 33 there is the reference to MA, but in fact it is not, it goes further, the direction required goes further in recognising that those parts of an appellant's accounts that are consistent, considering in the totality of all the evidence that there is, are such that, notwithstanding false parts of the account, that the appellant or the individual concerned can still be determined to be a victim of trafficking.
Well, is that part of the Lucas principle in Lucas itself, or is it just a general rule of credibility?
It builds on what's set out in the Lucas principle, my lord. So the Lucas principle, in terms of when a lie can be corroborative, and taking that further in as a standard of fairness, and how lies as well as truths are to be assessed, that one does not necessarily knock out all the other.
Have you given us the M case that the judge quotes in the last part of 33?
We've set out MA.
Yes, I know
MA
you've
is
got MA,
included.
but MA is in. Have we
MA
got
is
M?
included. M. No, we haven't, my lord.
And what the judge has done here is not, she hasn't set out in exhaustive detail the principles to be derived from these cases, but she's summarised the principles by reference to the cases.
And there's then a second part, my lord, which is the way in which, if at all, then applied that in her reasoning, which we say is not made out. Can I then turn to the factual background to some extent? I'm conscious not to provide too much specific detail because of the circumstances around the appellant.
And the live stream, yeah.
Yes. So, but what I would like to refer your lordship to, because this all feeds into the level of anxious scrutiny or not that was applied, is first of all the extensive documentation that was before the decision maker, all of which is obviously relevant in then assessing whether the decision is one that is sustainable. And
sorry, just to check my note, that's at 161 of the bundle, is that right? To 162.
the decision itself. So what you have, my lord, is the list, and in fact, at this stage, at the time of the decision, the appellant, there's some 10 or so items relied on that hadn't yet been disclosed to the appellant, and they were later disclosed in these proceedings. But essentially, what the decision maker had was over a course of time, from June 2017 through to 2019, where the appellant gave a very detailed statement, and then eventually the decision on 11th of November 20, a number of different types of documents, all of which required proper analysis. And
can we just see what the strands of evidence are? We've got the appellant's account, which she's given at various times to various people. So that's her own testimony. We've got some documents that were supplied, like photographs of her, Miss Malaysia and all that sort of thing, which, as far as I can see, don't show trafficking. They show her educational background, that sort of thing.
Her journalism, her work,
professional qualifications and so on, yes, but they don't, as far as I can see, show that she was, or even suggest that she was trafficked.
But they do, I'm sorry to just interrupt very briefly at that point, but what they show, and it is, that's the nature of these cases is they require piecing together of all the evidence that there is. And what they show, for example, the beauty pageant, the evidence that she has of that supports what she says as to how she came to be trafficked, and exactly that scenario matches and is found to be highly consistent and in fact referred to as a form of grooming by the trafficking expert, Dr. Lewison, it also ties in with what Dr. Wooten says. So whilst on its face, my lord, it might just be evidence that she took part in a beauty pageant, it is a further quite essential jigsaw piece, if you like, which has to be taken with all the other jigsaw pieces to then reach the conclusion as to whether or not this individual was exploited. I'm sorry to have interrupted, but it's
right.
to make the point that actually, whilst there's evidence which on its immediate face might not do very much more than just simply show that an event has taken place, in fact, on the intensity of review that is required, it potentially has much more significance.
Yeah. All right. And then the third strand is the expert evidence.
Yes. But I would go further and say that an additional, well, actually there's two additional, there's the expert evidence, sorry, three things actually to say on that, and just so that I don't forget them, to take a note. On the expert evidence, it's not just that the expert evidence says what she's told me is consistent with what I have diagnosed. It's the diagnosis itself. And you have that, I keep going back to TVN, and that's because TVN just so comprehensively sets out all the principles to be applied, and particularly which we rely on, draws from the statutory guidance 10 key points. And the two final of those key points are that what is to be done with a diagnosis of PTSD, and specifically what is to be done with a diagnosis of complex PTSD, because complex PTSD indicates multiple trauma, and that in itself almost stands on its own as supportive evidence. So that is that's what the expert evidence gives you, and then you have the trafficking expert. And also, though, my lord, it's right she gives different accounts, but it's how she gives those accounts and the circumstances of those accounts. So I'm thinking in particular of the police interview record that took place. So there were two sessions of police interviewing. One was on the 25th of April, when she was first found by a passerby. And by reason of the state that she was found in, that would have indicated that she was likely to have been in a state of trauma, that in itself. But we don't have the interview record of that. We just have the NRM referral, which again sets out her consistent account. And then there's a second session of police interviewing, which takes place on the 3rd of May, and that is divided up into 4 parts. And it's not simply the version that she gives, and this then comes back to how an account is to be assessed, but throughout it, what she says about why she gave a false account when she was first apprehended. She says, I'll take you to the references, but it's important because she says that she was first told that if the trafficking occurred in the UK rather than abroad, she would be deported. She says that she's scared. She gives evidence of self-harming. She gives evidence of just repeating what she had experienced before. So it's not simply her version, it's in the context of how that version is conveyed. And that, again, is part of the very complex, and which is simply not adopted in its approach by the in the conclusive grounds decision, the very complex forensic analysis that is required in deciding whether someone is a victim of trafficking. Yes, Mo. So I think that's in terms of dividing out what is before the decision maker, and that does not come out in the decision.
Which decision?
The conclusive. Sorry, I'm sorry. The conclusive.
Yeah, no, sorry. I'm
Yes,
just making sure that
yes,
you mean
the conclusive grounds
the
decision.
CG decision rather than the judges. Yeah.
Yes. In turn, it's not the CG decision, and then the judge was addressed on all of these points at length, and they are not engaged within the judge's decision. So you have, for your reference, you have the 29th of June 17 GCID Border Force summary and handwritten interview. You have the 20th of July 17, which is the second time that she was apprehended, and she immediately admitted to being Albanian. GCID, very short encounter. The NRM referral, which happens very early on in the sequence of events, that's on the 25th of April 2018, and her whole account in terms of what happened to her, how she came about to being trafficked in Turkey and then returned to Albania and then Belgium, is all set out. You have the MG3, which is the 3rd of May, in 4 parts, a very lengthy interview which has a lot of, in my submission, essential evidence that must be put into the mix. You have the pre-sentence report. Again, the writer of the pre-sentence report refers to her accounts of Turkey, Albania and Belgium. You have the handwritten statement of her, which again is another very, very important piece of evidence, my lords. And in fact, we have, on that handwritten statement.
What date is that statement?
That is at 325. I don't know, that's the transcript. And we have a transcript of that. Because, yes, this is in her own hand, and again refers.
This is in the supplementary bundle.
Yes, 325.
325.
We've typed it out because it's not as legible as it could be in all its places. So it's 3. Thank you.
Thank you.
Thank you.
Thank you very much. And this is 12th of July 2018, is that right?
Yes, my lord. When you, if you look at the 328 where she signs it,
Yeah, I've got that.
you've got that.
Yes.
And my lord, you'll see so her in her own hand version begins at 325, and at 324 again this is her claim for asylum.
Yes.
Again, her handwritten, where she says, she explains about lying, and she says why. I wanted to protect my life. Then you have also, to feed into the assessment, the Oasis report. That's at 368, dated 7th of August 18, where she refers to being a victim of trafficking.
Sorry, which page?
It begins at 368, my lord.
Thank you.
And the specific reference, my lord, is at 374, and it's the penultimate paragraph.
So this was done for the sentencing exercise,
Yes,
is that right?
yes. And it's dated, I think, 7th of August 18.
Yeah, you've got that top right.
Yeah. My Lord, there is then, again, this is where I rely on her version being seen in the particular context in which it's given. At 329, her initial contact assigned registration questionnaire and screening interviews. So this is 29th of August 18. And then if I could ask your Lordships to look specifically at page 333, where again she refers to having been trafficked.
Yeah. The answer to question 2.5.
Yes,
Yeah.
exactly. Turkey, Albania, Belgium. Again, the consistency there. And then there's further, that continues to 339.
Yeah.
And then these are representations, so in my submission they won't have the same weight as her handwritten statement, but they are grounds that were relied on for her bail application at 341, where again, paragraph 3, she refers to the trafficking.
Yeah.
And then finally you have, as you mentioned at the outset, my Lord, her statement, her very detailed statement, which is in the bundle at supplementary bundle 1 to 22, and that's dated 7th of March 19.
Yes.
And I will take in a moment to then the expert evidence that you had as well in support. In terms of the chronology, my Lords should have a detailed chronology at core bundle page 54 to 57. And for reference, my Lord referred to so 54 to 57 sets out the detailed chronology, specifically, and in terms of the evidence supporting the chronology. There is the evidence of her working as a journalist in Albania, the evidence that your Lordship has already referred to, and that for your reference is at supplementary bundle 193 to 207. There is the evidence supporting her working or taking part in modelling competitions in the beauty pageant, which is at supplementary bundle 190 to 192. After that, my Lord, I'm looking now at page 4 of the skeleton argument. She's first taken to Turkey, and in her account as to how she was treated in Turkey, that all has specific reference, because when these accounts are presented to the trafficking expert, Dr. Lewison, she specifically sets out in great detail in her report that all of these are indicators and consistent with the pattern as to how victims come to be trafficked, specifically the action that's taken, which is her recruitment, the means in terms of her being threatened, she and her family being threatened, which she sets out, and for the purposes, as she set out throughout, for sexual exploitation purposes. In the chronology, this continues when she's returned to Albania, and I'm looking at paragraph 8 of the skeleton. And the first time that she's stopped by the authorities, UK Border Force, is in June 17.
So are we in the skeleton or the chronology?
We're in the skeleton at paragraph 9, my Lord.
Thank you.
Page 4.
And at that point, she said the problem was her father had borrowed money.
Exactly. But she also says, and this is why it is so important, because it is recognised, particularly in trafficking cases, that that there may very well be inconsistencies, and also by reason of the trauma suffered and by reason of the mental health that develops from that, the onset. What she also says is, may I take you to 299, which is the
299
in the supplementary bundle.
So this is June 2017.
Exactly, my lord. So the record begins at 294. The summary of that record is in the GCID case note at 292, but I would like to take you to the actual handwritten record, and specifically 299. Can I ask your lordships please to read her answers to questions 44 and 45? And again, relying on that, as that is all part of the totality of the evidence before the initial decision maker, and then what is reviewed by the court below. After that,
The reason that she was claiming asylum is the answer to question 7 on page 294.
Yes, that's absolutely right. And she accepts afterwards, she accepts that is false, but she also says that at that time she was under the control of the traffickers. Yes, and that's absolutely right. The next encounter...
But part of the problem is that the fact something may be true doesn't necessarily show that it is true. And this is a case in which the appellant has to show on the balance of probabilities that she was trafficked. Isn't that right?
No, the statutory guidance is silent as to there being any onus on her.
Right.
What the statutory guidance says is that the decision maker weighs up whether on balance she's a victim of trafficking. That's the question that the decision maker must return to, not whether she's telling the truth or not telling the truth, because she might not be telling the truth, but there might be parts that, in fact, when she's assessed on those parts, and there is expert evidence, as there is in this case, both medical expert evidence and expert evidence from a trafficking expert, that in fact that all demonstrates in its totality, along with the diagnosis, in this case complex PTSD, that she is a victim of trafficking.
Could you show?
So the credibility is one part, and also I'm sorry to just make this point. The guidance actually goes further, and this is taken up in these 10 key principles that I keep referring to in TVN, which is that credibility doesn't even necessarily have to be assessed. It is part of it, it is not determinative of it, and...
Well, Mr. Lott says there may be other independent evidence,
yes,
which shows that somebody has been trafficked, but apart from the expert report, there is none in this case, is there?
There's all the evidence in the medical records. That is, fortunately, all the relevant extracts, because the medical, and I should have said actually at the very outset, because that's another part when your lordship listed all the evidence that there was. That medical evidence is summarised first by, in part by Professor Katona, and in part by Dr. Dunmore, and then in detail by Dr. Wooten. And all of that is independent evidence as to the symptoms that she displayed right from when she was first incarcerated on remand, right through.
But the evidence is the expert assessment of those records, isn't it?
I'm sorry, my lord.
The evidence is the expert assessment of those records. That's
But
the evidence upon which you rely.
But it's also, in my submission, it's also the entries themselves in those records, because the entries show right from the outset, by different authors, setting out that she presented as vulnerable, as very sad, as very quiet. She self-harmed. There were a number of she tried to take her own life. How she responded in particular therapy courses. So all of that going through, she became extremely distressed. That all is evidence in addition to what Dr. Wootton says about the evidence in my submission. So
would you, I'm sorry for being slow, would you show me where in the, you had an exchange with my lord a moment ago about the onus of proof.
oh yes.
And you didn't agree with the way my lord characterised it. Could you show me, it might help me if you could show me the document in the part of the guidance where you say you rely in the answer you gave to my lord?
Yeah. So if the two parts that I rely on to make good on that point, my lord, are first how it's set out, which is 14.85 of the guidance, which my lords will find at tab 11 and specifically page 1485 340
Of the supplementary
of the authorities bundle, my lord. Sorry.
Well, perhaps I got confused, but I thought that weighing the balance of probabilities was setting a test of balance of probabilities, but you say that's not what it is.
No, I was speaking about that it's not for her to prove it. It's on balance assessing.
Where does the onus lie then?
Well, it will be. It's not specifically. May I take you to the relevant parts, and then
Yes.
that might answer it in more eloquent terms. 14.85. Authorities bundle, page 340. So it begins standard of proof for conclusive grounds decisions 14.83. At the conclusive grounds decision stage, I'll allow you to read that. It's those three paragraphs, 14.83 to 14.85.
But I don't think that necessarily answers the point that I put to you. The fact that something might be true doesn't necessarily lead to the conclusion that it's more probable than not that whoever's saying what they're saying was a victim.
Yes, I mean, I'm not making a submission that it's lower than the balance of probabilities. No, I'm not.
The decision maker, one way or another, has to conclude that it is more likely than not
Yes.
that a particular person has been trafficked.
Yes. Yes.
And given that the assertion is made by the alleged victim, doesn't the onus lie on the victim?
Well, the
her?
reason that I say that it doesn't is just building on what the guidance sets out, and specifically, can I ask your lordships please to turn to 266 of the authorities bundle. And that is, and can I ask your lordships please to read paragraph, well, it says, is there an onus of proof, paragraph 35.
Did anyone refer Mr. Locke to the ECAD? Because obviously the guidance gave effect to the ECAD, which makes it perfectly clear that that if you are a victim of trafficking, or potential victim of trafficking, you assert that, and then the authorities have to consider your claim. So, I mean, fine, you can read the guidance, but if you read the guidance without looking at ECAD, you're effectively looking at a slight vacuum.
Yes, he was. Yeah. He was referred to it, my lord, and in fact sets out specifically the relevant articles at the outset of his judgment.
And why doesn't he pick up the relevant articles in this bit on onus of proof?
Well, he sets out. I mean, he sets out taking it from from the guidance, and I rely on specifically what is set out by that. I take on board your point, but essentially it's the guidance itself does not specify that it's for the victim, that it's for her to prove. And so, as set out at
Well, if
paragraph
it's on the
36,
balance of probabilities, it doesn't really particularly matter whose the burden is. I mean, the question is whether it's more likely than not.
yes, I mean that's ultimately.
But I think that's what my lord was putting to you, which is the fact that something is consistent of or indicative of doesn't necessarily get you over the balance of probabilities.
It won't necessarily, but that does not. That's not the point that we're making, my lord. The point that we're making is that the decision maker has to apply the guidance and has to apply this anxious scrutiny, and that requires all the totality of the evidence to be duly considered and properly and forensically considered, and that didn't occur here. Had that occurred, it may be the decision maker may have come to whichever decision on it, but it didn't occur. That process was not applied, and that is brought out by particularly by my submissions to you on all of this evidence, and they don't feature in any way within the conclusive grounds decision. So all of that, I say, further demonstrates the lack of anxious scrutiny, the lack of an understanding of how the guidance is meant to be applied. I was taking you to the relevant parts that the decision maker had before him, and the next relevant document that I wanted to take you to is there is the GCID summary, which is called Supplementary Bundle 310.
310.
Yes, my lord. And that is for completeness. Goes to what was before the decision maker. It doesn't tell you very much. Simply the circumstances in which she came to be refused entry, and she previously attempted to use another ID card. But then, importantly, directly after that, my lord, 311, which is the NRM referral.
Yes.
And that is important. That is dated the 25th of April 2018.
Sorry, just before we leave 318, because if one's looking and applying anxious scrutiny, it's an unusual feature of this claim that someone is claimed to have been trafficked, that you're then travelling with a family member into the jurisdiction, or a partner of a family member. What do you say about that?
Those are circumstances in which you arrived at that time. It's ultimately assessing whether someone is or is not a victim of trafficking will depend on the significant parts of the account, and actually in this case the significant parts in terms of the account that she's given repeatedly as to what occurred to her.
Well, has she explained, because I haven't seen it and it may just be an error, as to how she came to be travelling with this individual at that particular time, linked with the trafficking that was going on before? I think you were getting some assistance from behind, if you...
Yes. It's in her witness statement she sets out, which is the witness statement of March 2019. So then, if I may go back to 311, and because I'll come afterwards to her statement in any event. So 311, importantly, 312 and 313, at that stage, set out all the various indicators that she was displaying. And again, all of that goes into the assessment of her as to whether or not she's a victim of trafficking. And then...
So what is this from? When is this made? The same.
So this, my lord, this This was completed on the 25th of April when she was first found.
So this is, yeah.
This is her first encounter with the police.
Exactly.
Well, but this, the information she gave to the police at that time was it is now common ground false, which is why she was convicted of perjury.
What she said about her.
So can I just ask the question and then you can answer? So if that is right, when you're applying anxious scrutiny, what is the point of setting out all these indicia which are in this account, which is it's now common ground false? For example, the tick box which you've asked us to look at, which was unable to move out of the house without permission of the person, etc.
My lord, in my submission, it's all relevant because it feeds into it, and even though she did say, and she was convicted of the false account she gave us.
Let's ask then how that works. So if you look at section B12, limited contact with family, we now know that to have been wholly false. So what is the decision maker to do? Put down that she did say this, that's now obviously false, but I mean, the injuries, apparently as a result of controlling measures 5, are still there. I mean, is that what you're suggesting should happen?
My lord, yes, I'm saying that all of this is relevant to the assessment, and that needs to be taken in the context of what's then set out in the account afterwards, which, my lord, goes from 319.
But how is it relevant? If it's false, how is it relevant? What is its significance in the overall assessment? I mean, we've got a detailed account on 319, which is accepted to be false.
But
what do you say the decision maker should do with that account?
So there are a number of points that arise from that, my lord. The first is that the account, the very final part of the account, is false, but from 319 through to
the final part,
321. Yes, because when you look at, my lord, may I ask you to look at 319? This is
the heading "Escape from Boss." That's all false, isn't it?
But when she says history documented Albania 319,
Yes.
That's what she's always maintained happened
Yes.
to her. All of 320 is what she's always maintained has happened to her. All of 321.
Yeah.
So what I'm saying the decision maker needs to do is to assess all of this evidence, and if throughout the evidence what she has said about what happened to her prior to her arrival, taken with the reasons that she's given for why she lied when she was first apprehended by the police, all of that points to a consistency that in the totality of the assessment is of weight. It must be considered.
Right. So
In
your
itself-
point is that despite the fact that she lied about what happened to her in the UK, her account of what happened to her before she got to the UK has been consistent.
Yes, and also she has consistently explained why she lied.
Consistently explain why she
Sorry,
lied.
she has. Sorry,
She has inconsistent. She has.
No, I should put it in this way. When she finally has the interview on the 3rd of May 2018, I'll take you to that in a moment, with the police in the 4 different parts, she explains why she lied. And what she is consistent about, I should say, in terms of is she's consistent about saying the only part I'm lying about is how I came to be apprehended by the police, is the UK part. That is the part I've lied about. That is the part I'm sorry that I've lied about, but I lied about it because I was afraid. I didn't want to be returned to Albania. And then at one point she says about being told that if the trafficking hadn't occurred in the UK.
Are you saying that the judge, the decision maker and judge is obliged to accept, therefore, those parts of the account about which she's been consistent?
No, what I'm saying is that the decision maker is obliged to take account
Of that consistency.
Absolutely, because
I see.
and this is in YH. Every part that goes to the favour has to also be taken into account, and that goes to, and that's
Every part that goes to.
and that the
Yes, yes,
yes. If I
yes. Don't worry. Don't.
word
We'll
it
come to
in.
that later.
Yeah.
I know what
Yeah.
you're referring to.
So
Not
it's-
quite
it's,
like that. Yeah.
I can, yeah, I'll come to the exact, the quote, which is taken also with the intensity. And just as, I should say that just as the falseness of her account is striking, and she admits to that, she admits that she lied, equally, the consistency of what she, well, there's not just the consistency of what she says always happened to her prior to arriving in the UK, but at one point in the police interview, she actually says, when she's pressed on why in her original account she was actually having panic attacks and crying and becoming so distressed when she was supposedly giving this false account. And there are at least 2 references where she speaks of simply referring to what has happened to her, but in the UK context. And again, I mean, in my submission, it's not taken into account. But that explains why she's able to give such a vivid account and such detail. So, for example, that she's asked, she describes very vividly a house, a white house, and in the police interview, it said to her, well, we spent something like 2 hours speaking about this, and why? And she says that was the house in Belgium. So all of that feeds in to the totality of the evidence.
So I will understand that, and it's, you know, we spend our lives making decisions, and you would hope to be consistent and look at all the evidence. So we're looking at this decision maker's treatment of just this little bit of information that you've identified. We turn to page 170 of the bundle, and it says, it's noted you were found by a member of the public and taken to the police station. You provided an account to the police stating that you were approached regarding an opportunity in modelling, and then I won't read out the rest, but it does refer to Turkey, Albania, and then the UK. Now, that suggests that the decision maker did at least consider that part of the account, which you rely on as having been consistent with the final account. So what went wrong? Why should the judge have quashed that bit of the decision in relation to this submission?
Because, my lord, it's right that that's referred to, but there is no consideration given to the repeated consistent accounts about this. So this is what...
Well, that's not in fact entirely fair, because I've just taken you to the April 18 one. If you go up again to 170 at the top, when this is first coming across, there is reference to beauty pageant in the earlier part, for example.
Yes.
So it's not fair to say that the decision maker hasn't taken account of the consistent, and indeed has actually set it out.
Well, the number of different versions, my lord, and the fact of the repeated versions and the consistency in my submission, looking at all of that, and then specifically looking at the way in which it's set out, I say does not demonstrate the anxious scrutiny.
So what about the bottom of 169? Looking at the available evidence information as listed earlier in the decision, it is recognised you provided a detailed account of events, and your account is broad in line with the wider external evidence of victims of slavery for Albania. It's further noted that you have provided documents relating to your attendance of the beauty pageant. So that is a reference back to the available sources of information. Does the decision list the available sources that you've taken us to?
The sources,
amongst others.
Yes, the sources are listed at the very beginning as
Yes.
to what was considered. Yes, that's right.
So, isn't that the decision maker noting the points that you're making now?
Well, the decision maker is noting the evidence about the beauty pageant, but as I say, the point that we rely on is that the fact of the throughout from 2018 onwards, that what she repeatedly says and the detail of what she gives about what happened to her in Turkey, Albania and Belgium, in itself as a factor weighing in her favour.
You have given a detailed account, broadly in line with wider external evidence of victims of modern slavery in Albania.
Yes.
Isn't that the decision maker taking that into account?
Well, it's setting it out there, and then what I intend to do, though, my lord, is then come to what the decision maker says about the lies and the focus on the lies, and how the decision maker deals with mitigating the circumstances. I still maintain that yes, I accept the decision maker makes reference to that, but there isn't a consideration being given within the reasoning to the repeated consistency of the accounts.
So what, I mean, your point really is that if one goes to 169, the decision maker says it's recognised you provided a detailed account of events and your account is broadly in line with wider external evidence, etc. The decision maker should have gone on to say you have been consistent with that detailed account of events in a number of interviews with different people at different times, and the consistency of that explanation is a factor which counts in your favour.
Yes.
That's the point.
Yes. Yes. Yes, my lord. And in support of that, I've already taken you to that. The NRM, its pages for your reference. It's the bottom of page 319 through to 321. After that, this is now a particularly important document.
I'm sorry, just to pursue the thought that I was putting to you. The decision maker should have said that the consistency of the account is a point that counts in your favour, and the failure to say that demonstrates that not all points that counted in her favour were taken into account. Therefore, it fails the anxious scrutiny test, whatever that is. Therefore, there was an error of law.
Yes, in that regard, yes. No.
So if we look at the end of the decision, 173, the decision maker lists the information that supports the case, and then it goes against the case. Last few lines of 173.
Yes, no, sorry.
There's a wider external evidence, the scanned assorted documents,
Yes.
and the expert report.
Yes. There are further matters. So, for example, the medical records themselves, the context, and I'm going to take you to that now because I want to take you to the police interview.
And then, just so finishing my point, then the balance is that once about 10 lines down 174, look at the available evidence in the round of your case. You to consider that whilst there is some information that supports your account, looking at all the pieces of information cumulatively, the credibility issues outweigh the evidence in support of your account. And you say that what's not taken into account is the consistent, that the fact that some elements of the account were consistent across various accounts.
And actually the most important parts, which is her actual account of trafficking, her actual account of exploitation. Because that's what's always consistent.
Well, didn't she give an account of exploitation here as well?
No, that's what she says. That's what she says is. Oh, are you speaking? Are you?
Well, you're saying that her accounts of exploitation before she came here
Yes.
were consistent.
Yes.
But she gave accounts of her exploitation here, which were
Yes.
contradictory
Yes.
and false.
Yes. And which she explained. And I mean, I'll come to this moment. That also demonstrates this the what we've referred to as the Mabanga error in the sequential.
We'll come on to that too.
Yeah.
Just right. You don't say that. Do you say that the decision maker wrongly applied an onus? You say there's no onus of proof, relying on Mr. Locke. Do you say the decision maker applied an onus of proof?
Well, it is set out. It's not considered you have met the required evidentiary standard, which in my submission indicates that how it was put. But in my submission, I think there are many more, much stronger errors in this.
Well, a failure to apply the right standard of proof would be fatal to any decision.
Oh, the standard, but I was speaking about the onus, but it says required
Or
evidentiary
burden of
standard.
proof then.
But it's set out what our submission is as well on this is that in fact the wrong question, the focus is on the wrong question. The focus is on is she lying rather than is she a victim of trafficking. But what we say on that is that indicates that you have met. It's not considered you have met the required evidentiary standard. Suggests that the onus was put on her. And we say, relying on the guidance, that that's not what the guidance says.
So, I mean, are you trying to say that the decision maker applied a burden of proof which should not have been applied? And if you are saying that, is that a ground on which A, you applied for judicial review, and B, a ground on which you have permission to appeal?
My Lord, I will leave that point. It's not our two main grounds, as I say, the anxious scrutiny and then the
Just, I'm sorry to bang on about the onus of proof point, but apart from Mr. Locke, I'm not, that sounds dismissive. I'm not dismissive of Mr. Locke at all. But is there any, because Mr. Locke's decision came after the judge's decision in this case, is there any other authority for the proposition that there is no onus of proof?
Not, my Lord, not that we have relied on. We've taken it from what's set out.
I mean, if a claimant makes a claim, based on an assertion, doesn't there have to be an onus of proof? One way or the other.
Well, I might think also, particularly where the assertion relates on events which have all taken place abroad.
The exercise that the decision maker carries out is to consider all of the evidence and then reach this decision on the balance of probabilities is the individual victim. So it's not.
What's the decision? Is the claim established?
Is this person a victim of trafficking rather than has this person made out her case? Is this person a victim of trafficking? And that's how we put it. I
mean, the assertion is this person is a victim of trafficking. That's the assertion, and the question is whether it's established. And the assertion is made by the claimant. anyway, probably,
Yeah.
I'm just I was just curious to know the origin of Mr. Locke's principle, the principle he sets out at 35, 36.
Well, the reference is, yes, is by the guidance. My lord, the next document, which is again feeds into the overall exercise of what was before the decision maker, is the police interview, which is on the took place on the 3rd of May 2018. And that is in the supplementary bundle at page 385.
Sorry,
385.
85.
Supplementary bundle 385.
85.
And the specific references that again required consideration and analysis and scrutiny that I rely on are in the first part. So it begins at 385 and then what she says at the top of 386. And this is a theme running through it where she says everything I told you. So the first, if I could ask your lordships to read that, please.
From where?
The very beginning. I feel very sorry that I lied to you.
Mm-hmm. How far do you want us to read?
Just that first part when she
Yeah.
says everything I told you. And then, my lords, the last section on that page, 386, where she
Starting they will
explains-
not inaudible.
Exactly. And again,
Sorry, just hold on a minute.
Yeah.
Who's DP?
that's the appellant, my lord.
Detained person.
Ah. So some of her answers she gives in English, does she? And some
Yes.
through the interpreter? Is that
Yes.
how it works?
Yes, my lord.
Right.
That's how it reads.
Yeah. Yeah.
And we say that obviously that provides context for the accounts that she gives, and then that again at 387, the penultimate answer next to interpreter.
And because my boyfriend, that one?
No.
If I told
above
her
that,
everything.
Exactly.
Yeah.
There's reference to text here. What happened in the police investigation? Because I see there's reference to substantial amounts of money being spent and a large police investigation. That rather suggests that the mobile phone is likely to have been taken. What did that show in relation to these texts that are referred to in the police interview?
From the sister, my lord.
No, not from the sister. From the person identified as the person trafficking.
Oh, we weren't provided with those. Yes. We've asked for these, and we still don't have those. We've asked for a number of items. We asked for within the CG decision. There's reference to additional information. We've asked for that, and simply been told this is Home Office records, and not been provided with it. We asked for the first interview, haven't been given that, and then the text, my lord, with the appellant's sister, we don't have those.
Well, the appellant's sister, it's you know the alleged master, as it were, or slave master.
And then, so at 387.
Sorry, just to chase it out, 387 at the top. Before if we just call the person who the slave master text my sister, now that's not going to be in the police possession because that's to the sister. Do we have the sister's text on that?
You don't, my lord. No. No, we don't.
But if you've asked the police for the text that they've got, you no doubt will have asked the sister for the text she's got, especially if it's one from the alleged slave master.
We don't, my lord.
Well, I mean, that's a sort of evidence that might be a slam dunk in this sort of case, isn't it? If you've got a text from the slave master.
Well,
I mean, subject to other explanations for a text, etc. But I mean, there was nothing adduced on that.
not as far as I'm aware. If I may have a moment. So I'm instructing my lord that her sister didn't have the phone anymore, so she doesn't have the text. But we don't have those texts.
Okay, thank you.
So the references again, tying in with what she says before about why it is that she lied about what happened to her in the UK. 387, you have that where she says the things you experienced. I was so depressed I didn't know what to do. I'm going to report, but they told me they're going to return me to Albania because the things I experienced did not happen in this country but in Albania. And then she says again at 388, my lords, 6 lines down, they would return me to Albania. So all of this bears out what she later says in her witness statement about how scared she was. And then also, which provides the context of her within this interview, she says at 389, she explains, this is the entry next to interpreter. I was going mad, I decided to do it, I don't know. And then, my lords, part 2, she says, again, page 393, this is the next to the second hole punch with interpreter. Can I talk something? I told you everything I have to. I told you everything that was true, but I also told you about what I lied to you before. So again, the relevance of her having said what she's lied about and being consistent in what happened to her before she arrived. And then it said that we spent 9 hours talking about what you say happened. Again, at 395, this is next to the second hole punch. I told you I was in those moments. I was depressed. I didn't know what to do. And then she says, again, I mean, these are all of this feeds into assessing whether or not she's suffered trauma and whether that's at the hands of the traffickers. 396, she talks about, I'm looking at the bottom of 396 next to the second hole punch, about the self-harming. 397 speaks about how she presented when she was apprehended. And then 397 at the bottom, the penultimate, where she says, I don't know what to say at these moments. She's asked about why she's hurt herself. I wasn't conscious. I didn't know what I was doing in those moments. I was thinking I was destroyed completely as a person.
So these are the injuries with which she was found in April 2018?
Yes, and then, again, I mean, all of this again feeds into what I say is, we say is the exercise of the totality of the evidence before the CG decision maker. 401. She gives, my lords may remember, she gives 3 different accounts about a particular aspect of how she's found, and she is pressed on that and asked about that. And she says at 401, so halfway down the interpreter, it says that I was sitting and thinking, as I told you about everything I did, it's not that I was sitting and planning. And she's asked about it, can you explain that? And then, can I ask you please to read what the interpreter says?
At where?
That's the next to the second hole punch.
Because of things I
Yes.
experienced.
Yes, my lord.
And how do we put that together with the fact that at the top of the page, the police have said, we found you with your arms taped together. How did you do that yourself? And she doesn't give a sensible answer for that.
Well,
Which, because that strongly suggests, and we won't obviously give the name, that the name of her then partner was responsible at least for some of the condition in which she was found. And the police obviously thought that was a position. And that obviously means that you're then having to, for understandable reasons, we all understand why people don't always give the full story to the police, but then, you know, if you're making an assessment of that, you're then going to have to discount some of it, because we all know as a matter of physical reality that you can't tape up your own arms.
yes, and she does say, she, and I'll take you through the other reference to it, she does explain that account, and she gave different versions of that account, that she did so because she was afraid, and she feared her partner, and that's why she said the versions that she did. And that all I accept, my lord. That all needs to be assessed alongside the context in which she says it, and that she maintains that in fact everything that's happening.
But you accept, do you, that it was open to the decision maker conducting the exercise to reach the decision that they did on all these matters. But you say that in getting that far, they didn't take into account matters which went the other way. You're not saying if she'd applied the right, he or she'd applied the right approach and taken everything into account, she would definitely have reached the conclusion that the claim was made out. You're saying that, or are you saying that?
No, I mean that's not how it's been.
No.
I in my submission on a proper analysis of all of this, it does point very compellingly and strongly to the fact that she is a victim of trafficking, but that's not how we put it. What we
Or
say
how you put it
is,
before us.
yes.
Yeah.
That's not how, what I'm like. But
No.
all of this feeds into it. You cannot separate, and that it seems to feature in the CG decision, the lies that she was convicted of from the context in which she gave them and the explanations that she gave for them. And that's what happened here. Repeatedly, the decision maker said, well, because of these inconsistencies, we then go to see whether they can be shifted. And in the judgment as well of the court below repeatedly refers to the false accounts, the lies, the patchwork of lies. And in fact, that's considering an element in our submission in wrong isolation.
Really, it's your case that the approach to lies here is sort of Lucas plus, in a sense, isn't it? Because Lucas tells us that a decision maker always has to take into account there are other reasons for lies, shame, etc. But your case is that in this type of case, the pattern of trafficking shows that lies are a common feature, and therefore the decision maker has to take that to be particularly aware of that fact in analysing credibility.
Yes, and in fact that reflects what the guidance instructs.
Yeah.
Instructs the.
I call it Lucas plus, but Lucas is, of course, Lucas is a sort of. It's a variable standard. Anyway, we'll come back to that in a minute, perhaps. Sorry, you're going through the records.
Yes, and I think had I taken you to
401 was the last.
and thank you.
That's where we
thank you, my
landed.
lord. So 402. Again, I told you it wasn't planned. The things she keeps saying this. The things that happened before I arrived here in Albania, especially. I told you the truth. and then the things that happen here, I just started talking and I was mentioning some things. And what comes out of this is that she has suffered trauma just by reason of the circumstances in which she was found. And so that goes on, that theme of her saying, I've lied on, and I've done so for these reasons, but I have not lied as to what I was subjected to previously. And then the other references, very briefly, because they at this point, are at. So this is a section, and this is our best indicator, or the closest indicator as to what she said in the first interview, because we don't have that. We don't have the transcript of that. And from 409, my lords, if you could turn to that, through to 413, the officer is repeating back to her what she has previously told them, and this is my consistency point about what happened to her.
Yeah, he's putting back to her the story that she previously told, and she's mostly agreeing with it, apart from one or two details.
Absolutely, which again feeds into it. So right from when she was first.
Sorry, I don't understand that.
It confirms that from the previous occasion when she was found, that the account she gave then of what happened to her in Turkey and Albania and Belgium, that is the account again that she gave then. It's not something that's later evolved or later emerged. And
no, but you got that in the original summary of what she said.
Yes, but then that ends with 413, which is again what she said throughout, is yes, everything's where she's asked so far, is everything I've said true? Yes. And then she goes on to explain, if you look at 414, she then says which bits are not true. That's the bottom of 414.
Yes.
And then finally, there is then the next part of the interview, and again, this follows on from a point I made earlier about the detail of the lies, and how, to some extent, this is explained at 426. And can I ask you, my lords, to read from against the first hole punch? It seems you've used that information to support your backstory. Is that why you did it? Why you said that you'd seen it before?
Sorry, whereabouts on 426?
426 next to the first hole punch, my lord.
Oh, yeah, thank you, sorry.
And then just to the second where she explains.
So she has been making up a story about other people in the UK being involved in sexual exploitation, and that's one of the things that's caused the police to go and look for these apparently missing persons, and all that's false.
Yeah.
And so what is being put to her is that she told that lie to support, quote, your backstory, unquote. Is that right?
Then, yes, and then she goes on to say, I'd seen before and experienced before. So again, that is all context. And then I'd made this reference to the house and the description, the vivid description she gives about that. My lords will find that at 434, where there's reference to her having been interviewed for 3 days. That's between the first and second hole punch.
434.
Yes, my lord.
Was this at the start when you said you were sorry? Yes.
It's that section and the next answer.
These are mostly questions. What are we supposed
It
to
just-
get out of this?
Again, that just goes to show that the accounts that she's giving, she's explaining how it is she provided the details she did. So it's not just the lie, it's the context in which she gives it. And then finally, 436. My lords, can I ask you to look at that next to the first hole punch? What were you scared of? And then she's described, and I'd mentioned this before. And then, my lord, you have the her witness statement, which is at the beginning of the supplementary bundle, and she sets out again her full detail. I don't need to take you at length to that, just for the purposes of, it begins at, page 6 of the supplementary bundle. And here she explains, again, she gives in much further detail her account of what happened to her and the exploitation that she was subjected to and why she was afraid then when she arrived in the UK. And then before I take you to the decision itself, the two other important documents are Dr. Wotton's report and Dr. Lewison's report. And if I may, can ask you to turn that up, please.
'72.
That's right, my lord, thank you. That's Dr. Wotton. And there were, prior to Dr. Wotton's report, there's the report from Professor Katona, which is at 62, and that's referred to in Dr. Wotton. And there's also the report from Dr. Dunmore, which is at 67. Now, the letter, the decision letter, the CG decision letter, refers in part of its reasoning rejecting the expert evidence to the expert relying on simply what was told to the expert. And my first point is that that is not right, because when you look at page 73, Dr. Wotton had a number of different sources of information going over to page 74.
You'll give us a reference to the CG decision in a minute, will you? Where you say it says that. It makes that mistake.
Yes, of course. I mean, I can.
Just to,
I mean, I can
think
immediately.
it's 371, yeah. Or 171.
not 371.
Sorry, 171.
So it starts at the bottom. Yes, thank you. It starts at the bottom of 171.
It's the second hole punch on 172. Considerable weight is placed on the reports. Emphasis must be placed on the fact that these professionals are not always privy to the vast amounts of information the Home Office has.
And what is the next sentence? Self-serving. Is that the point you make?
Yes. Based on what you've told them and what they've accepted in good faith. I mean, while you have this open, the way the expert report is, by the decision maker, concluded as not assisting the appellant, is to say, first of all, there's the capacity point, which is next to the first hole punch. It's considered the report does not provide any information to indicate you do not have capacity, and we say that's just a nonsense point. Therefore, little weight has been attributed to this. It misreads what is set out within the medical report about the context and.
Sorry, what page is that?
So that's 172. So
First hole
so
punch.
yes. So the reasoning as to the expert report begins with, however, it is considered that you have provided detailed and coherent, whilst there have been inconsistencies, this has mostly been addressed by your admission, it is considered
You made a point about capacity. Where is that?
yes, if you did not have capacity. So the decision maker is saying,
Sorry, which I'm just
Sorry,
whereabouts
where it
on
is.
the page? Yeah.
Fourth line of that paragraph.
it's next to the first hole punch. The paragraph begins, however it is considered, and it ends, therefore little weight has been attributed.
And why do you say that's just to make weight?
Because it entirely misunderstands the thrust of the Dr. Wotton's report and says because you don't have capacity, that means that
You do have capacity.
Because it says because you do have capacity, that means you knew that you were telling us falsehoods, and so for that reason, little weight is to be attached to Dr. Wotton's report.
In what sense is capacity being used? Is capacity referred to anywhere else?
No, Ronnie.
In what sense is it being used there? I mean, obviously, I start thinking about mental capacity.
Yeah, I mean, that's all it says. It doesn't.
Fitness to interview, isn't it? Because that's what Professor Katona assessed.
Professor Katona is talking about whether she's fit for her asylum interview. Yes, but the way that it's using this is to say, well, actually, we're not going to give weight to the Dr. Wotton's report because Dr. Wotton does not say that you don't have capacity. It's a non sequitur. But then the next reasons that are the next reason is that actually that the report, you're displaying the symptoms, but these do not mitigate for the inconsistencies. The next reason is that considerable weight is placed on reports in general terms by qualified professionals, but they are not privy to the vast amounts of information. And then the next point is the self-serving, and that's it. That deals with the entirety of Dr. Wotton's 30-page report. So going back then to Dr. Wotton's report.
Okay. I'm just curious about this capacity point. What is it? However, being a link word, suggests that that's designed to counter a point made previously.
Yes. So
And the law may be right. It may be related to fitness to be interviewed.
well, it quotes page 26 there. It's difficult for victims to want to relive traumatic events, with accounts being overgeneral or lacking in detail and consistency. It seems to be suggesting, well, the point flagged is that accounts may not be consistent, but in fact you did provide a detailed account, and because from the reports you have capacity, it appears that it's not that you did not have capacity to provide these accounts, and therefore little weight is to be attached to this expert. But I'm trying to make sense of a
To the point made in paragraph page 26, to the point in the previous paragraph. The assertion that because of trauma, I'm paraphrasing now, Mr. Briganza, so forgive me. The assertion we haven't looked at Dr. Wotton yet, Dr. Wotton's assertion that it's common for trauma survivors to have memory problems which impair the ability to provide clear, consistent chronologies and give it, and thereby affecting their accounts. That's what she means by, the decision maker means by capacity in that context. And what she says, he or she says is that that doesn't carry any weight here because, in fact, the accounts you've given have been detailed and coherent, and the inconsistencies have been addressed by the admission that they were false.
but then goes on to say, therefore, little weight has been attributed to this.
To
Which-
that
To
point.
that factor.
It-
not
it
to the-
might
not
be
to
to
the-
that factor.
Not
It does
to
say
the
the
report,
report.
but to that particular point.
What else can it mean?
Well, but then if you go on, because this is the only section dealing with Dr. Wotton's report, it's then set out, you're displaying the above symptoms, these do not mitigate for the inconsistencies and can be attributed. So that's the next reason that's relied on.
Yeah, and the symptoms can be attributed to the problems you face with your family in Albania and problems you face in the UK with the police and time spent in prison. And that's clearly a reference to Dr. Wotton's report.
But not in terms of what she says about it.
Well, we were
because
going to
this
show
will
us
come-
what
yes,
she does
yes,
say.
yes, yeah.
Yes.
But it's just to have that open, then, because
I
have
asked.
that in mind. Those two,
I asked you to
Yes.
show me the decision, so I led you astray. So
But-
where do you want to go,
but
Dr.
I mean, in any event, it's helpful because that is all that is said about Dr. Wood's
Yeah.
report. So to have that in mind, because the next point is the vast information,
Yeah,
and the next point is the self-serving.
yeah.
So the report is at, my lords, is at 73.
Yep.
Begins at 73, and so it isn't just the account. It isn't just merely an account. Dr. Wotton analyses the previous statement, the letter from Dr. Dunmore, from Professor Katona, you see all of that, the medical records,
Yeah.
and also the sentencing remarks,
Yep.
and so is fully aware of
Certainly.
the falsehoods, and also so has those sources before her. She has the interview with the appellant, and she carries out the mental examination of her. And she has the interview with her sister. So that, what we've just looked at, the CG decision reasoning, simply is not sustainable to say, well, this person was given, this is a self-serving report and just relies on the account that you gave. She then, she sets out at page 77 the references to the medical records, and this is what I'd touched on before as further independent evidence as to whether the appellant is a victim of trauma and a victim of trafficking, and detailing specifically. Can I ask you to look at, please, 11D and 11G?
Sorry, which page is it?
Supplementary bundle 77, my lord.
Thank you.
Yeah, and then there's a number of incidents
Yeah.
of self-harm
Yeah.
in the summer of 2018 that she refers to, and that's all while she's in prison, I think.
Yes, and that,
And Dr. Wotton then begins her conclusions on page 81, section 13, and she lists 8 different particularly traumatic circumstances. But that the appellant said it was the sexual exploitation which was the most difficult.
yes, and then
And then when we go to question 2 on page 87, which is a diagnosis, we get in subparagraph C that she's experienced ongoing and repetitive exposure to traumatizing and highly stressful situation. 4 lines from the end, early adverse experiences predisposed her to developing PTSD, and so forth.
yes.
And
Before she gets to that point, my lord, she does also she sets out the symptoms with which the appellant presents. That's
Yeah.
82 and 83, and also she completes the impact of events scale revised on her, and also the trauma questionnaire on her. So she carries out a number of assessments on her, and then also carries out an examination of her, which is at 85.
Yes.
So all of that feeds into, and then of course there's the collateral history
quite.
part.
Then she says at H on page 89 that she's not feigning her symptoms. She refers to the Istanbul Protocol, which I'm not quite sure what the relevance is. And then question 3 on page 90, she's asked to consider the likely causes of a mental health condition. And in B, she says, complex PTSD is typically associated with sustained, repeated or multiple forms of traumatic experience, etc. The events are those described in section 13. I do not think it possible to separate each event and commenting on it individually, as the effects are complex and cumulative. And then question 4A on the next page, she says the trafficking are the traumatic events which precipitated the PTSD. See answers above. But the answers above don't actually say that. The answers above say can't separate these various things.
My lord, I don't know whether that's entirely right, because at D she specifically says, well, she talks about complex PTSD in itself, indicative of the likelihood of suffering multiple trauma. And then at D, she talks about, we often talk about predisposing, and then she says, halfway down, there's evidence survivors, and then she goes on. My lord, do you have that, where it says there's also evidence survivors of childhood sexual abuse and violence display increased vulnerability? And then she says the appellant's adult experiences, and that's where she says are the events which precipitated the symptoms.
And which paragraph are you on? Forgive me.
So this is
Question
D,
3D.
page 90.
Thank you.
Of those adult experiences, and that's section 13. There's the one is little 4 is the relevant one for you. All the other matters are experiences which have nothing to do with trafficking.
Yes,
So what is wrong with the judge's analysis that it's difficult on the medical evidence to attribute all this to trafficking, given the very unfortunate background, a lot of which is independently evidenced?
my lord, the difficulty is that on a reading of the report says it's the trafficking that precipitated symptoms. She was predisposed to it by reason of the what had happened to her earlier in life, but it's the trafficking that precipitated. And whilst it's right, she says, about it being complex and it can't be divided out, but she's very clear in what she says is the precipitating trigger, and there's no evidence countering that. And in the absence of evidence countering that, in the absence of evidence undermining that, there's no similar expert examination or diagnosis. That is wrong to say that, in fact, her complex PTSD could be caused from what happened to her in childhood, because that's not what Dr. Wootton says.
Can we go back to how the decision maker dealt with
Yes,
this?
no.
You're going to come back to that.
Yes. I mean, I
because I'm for my part slightly perplexed by the paragraph, the next paragraph in the decision maker's decision, after the one we've been dissecting. It's acknowledged that although you are despairing the above symptoms, these alone do not mitigate for the inconsistencies between your accounts and your mental health, and can be attributed to the problems you faced with your family and problems you faced in the UK with the police and time spent in prison. Now, what do you understand the decision maker to be saying there?
well,
Leave out mitigate for the moment, because that's obviously a major plank of your case.
Yes.
What are is the decision maker saying there are inconsistencies between the accounts and her mental health?
Oh, I read that as saying that the symptoms of PTSD, which are acknowledged, can be attributed to the problems you face your family in Albania, etc. That is to say,
Yeah, I agree.
the traumatic experiences that Dr. Wotton refers to in section 13, apart from the trafficking.
Yeah, I agree. These alone, if we put square brackets up between the words "do" and the words "mental health" and that I follow. That means the symptoms can be attributed to the problems you faced. Okay, it's the words I put in square brackets that I'm sure it's me, but what does it mean? The symptoms do not mitigate for the inconsistencies between your accounts and your mental health.
And no, I think it's between your accounts, comma, if you
Yes,
put in...
that's
Yeah, well,
right.
that's the other.
That's
In
right.
other words, a square
That's
bracket.
how
Yeah, that's how I had
Okay.
read it or misread
So,
it.
in fact, the word "and"
Yeah, that's
is,
how I've read
is
it.
It's going on to a different bit.
and can be deleted.
Yeah.
Yeah.
Yeah. So, well,
Yeah.
a full
Yeah.
stop with a new
Or else
sentence.
there's something else after that.
Oh,
It's the
oh,
mental.
comma.
That fits in with
Yeah.
my Lord Justice Lewison's interpretation that the problems of your mental health symptoms can be attributed. Okay. Right. Thank you. That passed.
Yes,
now.
so the "and" comes. Yes, I can see.
So
that.
if
There's
we-
a-
if we
there's a
delete
comma,
"and",
You,
and then the
need,
"and"
you need to
comes.
put a comma before the "and", impermissibly, as it were.
Well,
and take out the "and" after the mental health.
Mr.
Anyway.
Briganza, I know we've
Yes,
asked you
I
a
know,
lot of questions,
I
but
know.
it's 25 to
I know.
1, and I don't think we've yet finished ground one, have we?
I know. Well, it's yes. I mean, it's difficult because it's in my submission it makes that whole point about the anxious scrutiny that it simply wasn't applied in this letter.
I mean,
But I
mitigate could be just the wrong word with respect to the decision maker. I mean, if the decision, I know you're going to say that it's in fact indicative of a wrong approach, but if the word had been explained instead of mitigated for or account for, then that would be that, wouldn't it?
Well,
Isn't that what the decision maker is in fact saying?
Well, what we can only go by what is set out here, and the decision maker repeatedly refers in this boilerplate style to this is the inconsistency, but this doesn't mitigate. So now we're looking to see whether it mitigates, and it doesn't mitigate.
Well, if leave.
Okay, and then goes on. Sorry, are you?
So your point of mitigation, as I understand it,
Yes.
is that mitigation only arises if you've made a decision or reached a preliminary judgment, and then you're seeking to mitigate its consequences. I mean, you've put it much better than I have, or you or Julia have. That's what you're saying, isn't it? But is that really what the decision maker is saying here? Isn't he or she really saying, wrongly using the word mitigate to mean explain or account for?
I don't know whether that's right, because that is an approach that features throughout the letter.
I know.
So,
Well, it's a word that goes throughout. And I haven't checked to see whether my suggestion that it's
we'll work on
a
the others.
misspeak, misspeaking applies to the other points. Anyway, I'm interrupting you, and my lord's rightly pointing
Yes,
out that
there's
you
the time
put
ticking
it
on. No, I'm conscious of that. I think you have my point about the expert evidence. It's effectively, in very cursory terms, it is dismissed, and given its potential importance and its nature, and the way in which it is prepared and what informs it, that reasoning very strongly demonstrates an absence of anxious scrutiny, and it relies on reasoning that is unsustainable, because those two reasons, they are wrong to have been included. And again, this sort of begs the question whether this is just copy and paste inserted. It is absolutely wrong to just throw in a general assertion that qualified professionals are not always privy to the vast amounts of information. That doesn't mean anything. It's not referencing Dr. Wotton specifically. It's not referencing what the information is that's being relied on. and it's not referencing how it is that Dr. Wotton's report is to be disregarded because of this information. So that is plainly wrong. And the second part, it's considered the account provides of a self-serving nature based on what you have told them, and what they've accepted in good faith is, again, that's just unsustainable. This is an expert, consultant forensic psychiatrist who has applied the Istanbul Protocol and by various means and tools assessed this individual. And to say that it boils down to being a self-serving report relying on what the appellant says in an accepting, uncritical way, again, is just a nonsense. It's not borne out by the content of the report. That, if I may just check that there's anything else on Dr. Wotton's report. No, the only other point for your reference is at page 96, where again, Dr. Wotton is referring to the state that the appellant was in, and all of that feeding into it.
Sorry, 96, which...
SB 96.
Yeah, no, it's just that it's quite a long page,
yes,
and I didn't want to look at it in my spare time.
It's the bottom of...
Question 12A, is that
12A, thanks very much.
And then the next report, again, Dr. Lewison's report. My Lords, Dr. Lewison, who is a chartered psychologist and clinical psychotherapist, applies her extensive experience and expertise in assessing and treating survivors of trauma, and specifically, the importance of this is that she lists, again, she doesn't simply rely on what the appellant has told her. She lists a number of different documents that are both favourable and unfavourable to the appellant. And then she lists my lords at page 115 through to 118, a total of 17 elements which she says are indicators. And she explains the basis for her assessing those as indicators, why they are indicators. And then at 119, and again...
Sorry, this section of the report is dealing with what the appellant told the police on first contact when she was referred through the NRM. Is that right?
Yes.
That's the part of the account which I thought you accepted in answer to a question from my Lord Justice Dingemans that was acknowledged to have been false.
Oh no, that's different, my lord. So can I ask you to look at 115? Yeah. So this isn't simply adopting the boxes that were ticked on the indicators of the NRM. This is Dr. Lewison analysing the evidence that she has before her.
I see.
And drawing conclusions.
Right.
And those conclusions manifesting themselves in 17 different indicators.
Yeah.
Yes. And so, and then what she also does, and this is, again, this in itself is very important evidence, and adds to what Dr. Wotton says. She says that for all these reasons, the account that the appellant gives demonstrates very strongly.
Sorry,
patterns.
where are you?
So I'm looking at from 119.
119.
Yeah. So this is my summary of what she's going on to say. So she goes through each part and talks about these patterns. So she starts at paragraph 39.
Mm-hmm. Yeah.
She talks about, which again is at the beginning of this morning, my lord, when we were speaking about the evidence about the beauty pageant. At 120, she talks about the grooming. So paragraph 40 through to 43. So the promise of opportunity.
Yeah.
And also you have within that the approach comes via social media, and there's also reference to that also demonstrates a pattern in how victims are recruited. And then she says at 44, sorry, my lord, did you have?
No, go on.
At 44 she says, I analysed the account to evidence patterns, which in itself is further important evidence feeding into what I describe as the piecing together of the parts. She then, again, which to some extent is taken on board within the decision letter, that actually the countries that the appellant is speaking of, that they match the profile that she's described, which is to her favour.
Yeah.
And Dr. Lewison actually goes further, because she says reference to Albania, and then specifically she says, strikingly at 49, at top of 123, is highly consistent with other victims of trafficking I have assessed, and she gives very detailed background of her experience.
That's picked up at the bottom of 169 in the decision letter.
Yes, there's reference to that, but then I'm going to take you to how Dr. Lewison's report is actually dealt with. Now, I recognise that, but that doesn't answer the way the letter then goes on in its reasoning. Over 123 then says, paragraph 51 at page 123, where she speaks about, next to the second hole punch, the means in the account is evident in the above description of historic vulnerability, as well as the deception, coercion, force and abuse of power. So all of this matches up, which is strong evidence. 124, page 124, she talks about purpose, where at 53 where the appellant was kept, and at 54 that her movements were controlled, and again comes to the conclusion at paragraph 57 that again this shows a pattern of movement between locations. And so the other reference are that she therefore concludes that the account is consistent. That's paragraph 58. At paragraph 60, she says that the experiences roughly follow a known trafficking pattern. And importantly, again, which feeds into the assessment 62 and 63, paragraphs 62 and 63 at page 126. Speaking about Albania and one of the top 5 source countries, and that in her experience, it's been the #1 source country. And so she refers then at 64 to the signs of grooming being evident. And then at 73, and I think that's my, the two final ones, 73 where she says that she's a vulnerable young woman who's clearly been subjected to extreme violence, at 73. And then finally her conclusion, her summary is at 135. Ms. Martini's presentation is consistent with that of other victims trafficking.
Sorry, just hold on a minute. 135. Sorry. Page 135. What? I'm lost.
Page
Where-
135.
Sorry,
where-
page 135.
Paragraph 88.
Page 135.
Page 135, paragraph 88.
Right. Yes, thank you.
The appellant's presentation.
Yeah.
And if we go back, my lords, then to how all of this is dealt with in the decision, that begins at page 172, bottom of 172.
Bottom of 172.
Yes, my lord.
Well, what about the bottom of 169, where it says your account is broadly in line with wider external evidence of victims of modern slavery from Albania? Because that's entirely the point that Dr. Thurleson has properly made.
Well, that is referring to what is set out prior to that in the preceding paragraphs about the trafficking profile, but
which is what Dr. Thurleson was also addressing.
Well, Dr. Thurleson, yes, she was addressing it, but she was also going much further in terms of the detail of the account and saying that it demonstrated patterns, that it was consistent with patterns in trafficking. But if I may take you to what is done with Dr. Thurleson's report.
Yeah.
Well, she starts by quoting paragraph 88. Sorry, the decision maker starts. I'm saying she, I don't know. He or she starts by quoting paragraph 88, doesn't she?
Yes. And then sets out.
Then makes a point about domestic servitude. Then repeats the point about mental health problems being attributable to problems in Albania. So, insofar as Dr. Thurleson has relied on Dr. Wootton,
yeah,
the decision maker is repeating the qualification that has just been made about Dr. Wootton, rightly or wrongly. Then she deals with
the part that deals with it is the section beginning with considerable weight.
Well, that is you say it's cut and paste. It's obviously cut and paste because
Yes.
it includes a misprint. Last line, what you have told them appears there as
In
it
the
does
same as
on the previous
previously.
page at the second hole punch.
Yes.
Right by the second hole punch. So that is a what is your submission about that?
Yes. It's the same, my lord. It is.
What do you say
Then
that shows?
It shows an absence of anxious scrutiny. I mean, it shows almost a style of just simply using template decision making. Computer says no, and then repeating computer says no how it's dealt with. It isn't engaging with Dr.
The fact that decision makers and judges use the same phrases in judgments is not by itself
No.
a lack of thinking. In fact, if you don't use the same phrases, you're in danger of being found to be inconsistent across judgments. But obviously, you say this goes further than that.
Yes, and also, my lord, again, I mean, even giving the benefit of the doubt to the writer, the same points apply to the reference to vast amounts of information, the same points apply to the self-serving nature.
And presumably your point is that these, in both cases, dealing with Dr. Wootton and Dr. Thurleson, these are general points made about expert evidence generally in this sort of case.
Yes.
And don't engage, is your point, don't engage with any specific weaknesses or problems or factors in these two reports.
Yes, my lord. And in fact, the precise wording is used in the decision letter in TVN. It's cited there. Exactly the same. I think rather than saying vast amounts, it says arrays, vast arrays of information. It's just the same. These letters are very often just set out in those terms.
They're very often in the same terms when they find conclusive grounds, and very often in the same terms when they find no conclusive grounds. But I mean, as to your suggestion that this is just computer says no, I mean, it did, according to the letter, and certainly evidence in other cases suggests, go through a second pair of eyes, etc.
It does say it here.
Yeah.
And in fact, I was looking to see, my lord, whether there was any reference to the guidance, whether the decision maker says, and I take account of the guidance, and there is one reference at the very beginning of the letter, but it says it makes that reference in the context of a second pair of eyes.
Yes, it says that, doesn't it?
But it doesn't say in the body in the body of the reasoning, it doesn't say having in mind what the guidance says.
Well,
no.
they wouldn't exist but for the guidance, because
Yes,
this is all
but-
one of the vices of the way in which ECAT has been given domestic effect, is that it's all on guidance.
Yeah,
And the only statutory basis is section 49 for give guidance, but that's how it's been done.
Yes.
So, I mean, it's plain they must be applying the guidance, otherwise they wouldn't be there.
Well, they're applying the guidance insofar as they're providing the decision, but whether they're applying the substance of what the guidance tells them and how to assess victims, for example, and to critically analyse, that's in this case certainly that's where we say, in fact, that hasn't happened. There isn't a critical analysis, and
Well,
certainly in Dr. Lewis.
do the points made in what you call the boilerplate passage, paragraph, repeated as we've agreed, do they find it have any origin in the guidance? In other words, or does the guidance say words to the effect that when assessing expert evidence, you have to take into account the Home Office has vast amounts of information that the experts don't have, and that by the nature of accounts, nature of the report, they're based on self-reporting, which is self-serving.
There's one reference, which is the use of the word mitigate, which has been described, I think, both in MN and also in TVN as the unfortunate use of that word. And so you can see there a lifting.
Have you got? Could you just show it again?
Yeah, where it is in the guidance.
If you can't do it now, then do it.
Yes, I can because I. So it's tab 11. And just if you give me a moment, my lord. And then I think it's so there's the reference.
Paragraph 1431 talks
Yes.
about experts not having access to the full range of information. It's on page 331.
Yes, and then
actually,
there's,
sideline.
it does use the exact. I think it may be that I.
Well, I've led you up this garden path. Why don't you come back to it at 2
Yes.
o'clock?
I mean that's all. But other than that, the boilerplate, they don't feature otherwise. And in fact, that's then. The same wording is then used in respect of Dr. Dunmore's report, which is at 173. Based on information provided, it's acknowledged you're displaying the above, however, they're not considered to mitigate the inconsistencies.
The decision letter quite clearly recognises that the appellant's presentation was consistent with that of other victims, that is Professor Dr. Lewison and also Dr. Wootton, which again was described as being consistent. And we know from MN, which we've got in our authorities bundle at tab 9,
Yes.
Yes, my lord.
that a finding of mere consistency is neutral. So you'd have to show that there was positive support.
Well, that is positive support, and in fact, in accordance
Sorry,
with the,
what is positive support?
so what Dr. Wootton says, in terms of her assessment, a psychological assessment, in accordance with the Istanbul Protocol, which is how she sets out her report, that is the conclusion. That is the way in which a conclusion is then framed. So that's where that's taken from. And yes, I know precisely the part that Your Lordship is referring to, but in fact, in this case, the way my submission is, the way that Dr. Wootton sets it out, she does say consistent. In fact, she says much more than that. And also, which feeds into my point about complex PTSD, she makes this diagnosis of complex PTSD, which I say is a standalone additional point. I'm sorry, my lord. Yeah, totally. And also, my lord, I am reminded that what is being referred to in MN also specifically came up in Mabanga is the scarring, and scarrings where the different categories are set out about highly consistent, or not consistent or typical, and that doesn't cross apply to the psychological assessment which occurs here.
Well, I'm going to stop you for a moment, Ms. Braganza. Mr. Keith, how long will you need for your submissions?
I'm not entirely sure, my lord. When we started this morning, I would have said 45 minutes.
Right.
It really depends on how far we spend all morning doing the detail of the.
Well, I won't necessarily hold you to that, but I think, Ms. Braganza, I'm certainly going to have to call a halt to your submissions by 3 o'clock.
Yes, I mean, I will be finished before then. I thought I might just be another, because I've dealt with most of the decisions. So yes, thank you, my lord.
Right. Well, you've got another 5 minutes before we need to rise. So carry on.
Can I just ask a question? Because this may be. You talked about anxious scrutiny. The judge below accepted there needed to be anxious scrutiny. Anxious scrutiny was started in asylum and protection claims.
Yes.
Is there any clear authority saying it applies to modern slavery? I'm sure there is. It's just no one's referred to it. And given it's a critical ground of appeal.
Yes. There is reference to it. Let me just find. So the reference is in MN at 213, my lord. Paragraph 240. And that goes through 242. There was no real dispute before us to the nature of the scrutiny. I can, rather than read it all out, I'll invite your lordships to read the whole of 242 and 243.
Thank you. So it's MN 242 and 243.
And then in terms of how that applies on a judicial review challenge, that's dealt with at 244, my lord.
Yes, although they then refer to lots of cases that are not modern slavery ones. But anyway, I mean, nothing turns on that. Thank you.
Right. I think I might. I recognise that I have a couple more minutes, but I think I might pause there, if I may, and come back. Because I think essentially I've taken you through all the evidence and you've seen my points and the reasoning.
Well, how long do you think? How much longer do you need?
Well, to take you to Mabanga, which is a relatively short point, and then remaining submissions on the Lucas direction. The judgment itself is very short, so I don't think I have many more points to take you on that. So I think within about half an hour, 30 minutes,
right.
40 minutes.
Yep.
And I'll wrap it up within that time.
All right, and then we'll break now and resume
Thank you,
again
my
at 2
lord.
o'clock.
What, guys?